Now, if you look at, for example, the California Family Code, it's pages and pages of not just sort of what we would call substantive guidelines. For example, they're very clear. There's a very clear statement that it is in the best interests of the child to have ongoing contact with both parents, regardless of their marital status. So that's a very clear guidepost for judges. But there's also a number of provisions that are quite clearly intended to limit the discretion of judges. For example, the California Family Code says you may not consider who is living with the child up who left the house. You can't, if you can't use the who is living with the child right now as the basis for the determination. You can't base the decision on the gender of the parent. You should base the determination on which parent is more likely to allow contact with the other parent. And there's a strong preference for joint custody. If joint custody is requested by the parties but not recognized, the judge actually has to give a very specific reason, and the judge can't just say because that's in the best interest of the child, because it's very easy for a judge to say blah 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 and that's in the best interest of the child. It's a conclusory statement. So the California Family Code goes so far as to prevent or attempt to prevent judges from doing that. I don't know how successful it is, but there's a great deal of effort in the law. It goes to limiting the discretion of judges. There's a number of presumptions. If there isn't an award of joint custody, then one parent gets sole custody, and the other parent gets reasonable visitation. And if for whatever reason the judge happens to write an opinion that doesn't mention visitation, then the parent gets visitation anyway. So there's just all of these. Somebody sat down and thought of all the tricks that a judge could use to generate a judge that he thinks is correct but isn't comporting with some very detailed law. And they've actually drafted provisions to make that as difficult as possible. Back to Japan, as I said, there's nothing. There's just these provisions in the Family Code, in the family relations section of the Civil Code that basically say, well, first there's no joint custody. Of course, during marriage you have joint custody, but after divorce, one parent has to assume sole custody, and if the parents can agree on that themselves, great. If they can't, then the judge will make that decision based on taking into account the best interests of the child. No definition of what is in the best interests of the child. And there's actually no provisions for visitation. There's no, that's something that the courts have actually invented based on sort of a general authority granted by the Civil Code to make ancillary determinations in connection with custody.
So in Japan, when people get divorced and there's children, what normally happens is that the children go with the woman in most cases. Is that right?
Well, before we even talk about that, one of the contradictions, the paradoxes about courts, the logic that courts use when they do make these best interests of the child determinations, is that most divorces in Japan take place without the courts being involved. Now, something like 90% of divorces are done by parents or couples just filing paperwork. Courts don't get involved. You don't need to go to court in Japan to get divorced. You go to your local city office. There's a divorce form. You fill it out. There's a column. If you have children, there's a column that you write the name of which child is going with the parent. You file that, and you're done. So there's this overarching presumption that whatever the parents agree to is in the best interest of the child, even if they're terrible parents. If one of them's an alcoholic, if one of them's all sorts of terrible things could be agreed to. in this situation, but the court system just doesn't even see it. And there's been some a recent case where a teenage boy committed a very horrific murder unintentionally, and it turned out that his parents were divorced, and part of the divorce conditions was that he never see his mother again. So, is that in the best interest of the care? The system doesn't care because they're not involved in most of the divorce and child custody determinations to start out with. So if you're a couple and you have children and you can't agree on the terms of your divorce and just fill out the paperwork, which frequently happens, I think, with children, when there are children, because custody is very much an all or nothing situation here. Then you go to mediation. And the purpose of mediation is for the court system to help you reach an agreement. So again, if in the course of mediation you're able to agree on custody arrangements, then good, you're done. The court will stamp that. And again, if it involves, say, an agreement that the child will never see a parent again, that's fine. So once you've filtered out all of the people who can discuss and resolve their problems, then you're left with the cases that the courts need to resolve. But of course, the courts don't have any real guideposts, external guideposts in terms of law. And in fact, it's actually, in some ways, it's almost being generous saying that there is no real law. It's almost correct to say that what law there is on related to these issues, the courts have actually come to sort of ignore. For example, Japan is a party to the International Convention on the Rights of the Child, and that convention states quite clearly that children should have contact with both parents after divorce. I don't think I've ever seen that mentioned in a Japanese court decision. The Japanese Constitution, not only the Japanese Constitution, the Civil Code, and the Family Court Practice Act itself all have this statement about the fundamental equality of the genders being a foundational principle. And yet there's this give the child to the mother. There is a manual written for family court practitioners where that's the only criteria used that it lists for making custody determinations. It's give custody to the mother. And somewhere else in the same manual, there's a statement about the fundamental equality of the sexes, and there's not even any cognitive dissonance apparently on the part of the people making these decisions and writing these things. And on the one hand, you have this very clear legal principle of gender equality. On the other hand, you have this, well, it's a very easy standard to apply. Let's always give custody to the mothers. There is the current sort of standard view of what is custody is that it's really more a set of obligations of a parent to the child and maybe to society as a whole, rather than a set of rights that a parent can assert, which again, the Civil Code in its provisions defining custody says that the custody is a set of rights and obligations. So there's almost this effort to change the law to something that is convenient for the people within the system. And I think that's really the big difference